consider a resolution that would terminate President Trump's national emergency declaration and prevent unallocated funds from being used to construct a border wall along the U.S. southern border. The full House expected to take up that resolution tomorrow. We see the chairman and the ranking member in the room. Also at this meeting, members will consider the rules for debate on gun legislation that would require a background check for all firearm sales or transfers. That's also on the House agenda for this week. We expect things to start shortly. This is live coverage on C-SPAN 3.
The Rules Committee will come to order. Today we are reading two bills, H.R. 8 and H.R. 1112, to close loopholes and strengthen our gun background check system. These bills are targeted and they take reasonable steps that an overwhelming majority of the public agrees with. A Quinnipiac poll found that 97% of Americans, including 97% of Republicans, support universal background checks. You can't get a majority of Americans to agree on anything, but they agree on this. 100 Americans are killed with guns every day in this country. This is a uniquely American problem. And one of the things that Democrats stated last year over and over again is that if we were fortunate enough to take back the majority here, that we would not sit idly by when we are in a position to take action to save lives. We're also planning on a meeting on HJ Res 46, which is a privilege resolution that uses a mechanism in the National Emergencies Act to terminate the president's recent emergency declaration on the wall. The president's promise at a campaign rally does not make something a national emergency. You don't have to take our word for it. The president himself said at his recent press conference, and I quote, "I didn't need to do this," end quote. Opposition to this declaration runs across the aisle and across the Capitol, and we are going to move swiftly to terminate the president's unlawful action. Before I turn to our ranking member, I want to recognize that Natalie Nixon, our Director of Legislative Operations, will be leaving our committee this week after being on staff since 2015. She has kept things running here smoothly, and there was never a problem too big for her to solve. Natalie will not be going far. She will be returning to the Homeland Security Committee, but our loss will certainly be Chairman Thompson's gain. You know, sometimes members around here get upset when you quote unquote steal their staff. Chairman Thompson doesn't. He just steals them back. And I want to wish Natalie well. I want to thank her for her service to this committee. And now I'm happy to turn it over to our ranking member, Mr. Cole, for any comments.
Thank you very much, Mr. Chairman. And we want to join you in wishing Natalie the very best. We will miss her. But as you say, she won't be far. Mr. Chairman, today's hearing involves two bills regarding background checks for gun purchases. While I understand the majority's desire to do something, anything about gun violence, I think both these bills are misguided. The cumulative effect is simply to make purchasing or transferring a firearm much more difficult. These two bills do that by forcing almost all purchases or transfers, with a few limited exceptions, to be done through a federal firearms licensee, and by making the background check process longer and more onerous. While I agree with the desire to keep guns out of the hands of dangerous criminals, I believe these bills will not accomplish that goal, and instead it will only make it harder for law-abiding citizens to exercise their Second Amendment rights. I have significant concerns with the new background check procedures outlined in these bills, and I'm concerned that the majority has drafted these bills, particularly the failure to define the term transfer more appropriately in a way that will criminalize even the most trivial of conduct of law-abiding citizens. Further, for many of these concerns could have been resolved had the Judiciary Committee allowed a more open process to amend these bills. I look forward to addressing this process with our witnesses. Finally, we are on short notice reviewing a bill to disapprove of the President's emergency declaration for the southern border. Over the last several weeks, I've repeatedly asked the majority to engage with the administration on border security, and I appreciate that the recent appropriations package took these requests seriously. However, I do not understand the haste with which the majority is pushing this disapproval resolution through. We've had no time to review the bill, and no committee has held a hearing or marked it up. Though the majority is not required to do so before March, I note that this is now becoming a common occurrence for the majority in this committee, and I would strongly urge them to reconsider this habit of bringing bills to rules that have not gone through a hearing or been marked up in committee. For these reasons, I'll be opposing these bills and their rules. Thank you very much, Mr. Chairman.
Well, thank you very much, and we're delighted to have Mr. Nadler and Mr. Collins here today, we welcome you both, and if you have anything in writing, please pass that on to the stenographer, and it'll be entered into the record without objection. I now recognize the gentleman from New York, the chairman of the Judiciary Committee, Mr. Nadler, for any comments he might want to offer the committee.
I thank Chairman McGovern and Ranking Member Cole for the opportunity to testify concerning two important bills reported by the Judiciary Committee, H.R. 8, the Bipartisan Background Checks Act of 2019, and H.R. 1112, the Enhanced Background Check Act of 2019. These bills are long overdue measures that will help address our national crisis of gun violence. Nearly 40,000 Americans lost their lives because of guns in 2017. In fact, every day in America, on average, 34 people are murdered with a firearm, and more than 183 people are injured in an attack. Gun violence of this magnitude is a distinctly American problem. A country-to-country comparison is shocking. For example, in 2011, the United Kingdom had 146 deaths due to gun violence, Denmark 71, Portugal 142, and Japan just 30. The United States over 33,000 that year. A recent study in the American Journal of Medicine found that compared to 22 other high-income countries, the gun-related murder rate in the United States is 25 times higher. 25 times higher. Even when you adjust for population differences, Americans are disproportionately killed by gun violence. We know the reason for this stark difference between our country and the rest of the industrialized world. The common factor in all of these other countries is that they have stronger gun laws. In fact, when Australia tightened its gun laws a few years ago, both suicide rates and homicide rates in that country plummeted. Our nation, however, is awash in guns, and we have the shameful death toll to show for it. One of the most important things we can do to address this epidemic of gun violence is to enact universal background checks. Under current law, only licensed firearms dealers are required to conduct a background check before transferring a gun to another person. This means that gun shows, online sales, and other private sales can completely evade this vital tool for ensuring that guns do not get into the wrong hands. According to one study, 22% of gun owners in the U.S. acquired the most recent firearm without a background check. We do not know if they were felons, fugitives, or domestic abusers. We do not know if a court had determined that they were seriously mentally ill. A huge volume of guns was sold with no questions asked. It is time to close this dangerous loophole. That is why we must enact H.R. 8. Citizens across the country have been organizing and demanding action, and now there is overwhelming public support for universal background checks, 90%, according to one recent survey. This bill would make it illegal for any person who is not a licensed firearm importer, manufacturer, or dealer to transfer a firearm to any other person who is not so licensed without a background check. Individuals seeking to transfer a firearm under this measure would be required to visit a licensed firearms dealer to run the necessary background check before the transfer could be finalized. The bill also provides a number of exemptions to this requirement, including gifts to family members and transfers for hunting, target shooting, and instances of imminent death or great bodily harm. The FBI's internal assessment demonstrated that checks processed through the National Instant Criminal Background Check System, often called NICS, are approximately 99.3% to 99.8% accurate. And in 90% of cases, checks are processed within 90 seconds. H.R. 8 will provide an accurate and speedy mechanism to help ensure that firearms do not end up in the wrong hands. There is no reason to continue to make it easy for people who are legally prohibited from possessing firearms to acquire them. H.R. 8 would close this dangerous loophole and would save many lives. That is why I urge its swift consideration on the floor. and passage by the House. There are also steps we can take to make the current background check system more effective at blocking the sale of guns to individuals who are ineligible to purchase and possess them. And that is why the Judiciary Committee also reported H.R. 1112, the Enhanced Background Checks Act. H.R. 1112 addresses a dangerous shortcoming in the current firearms background check law. This loophole enables, in certain cases, firearms to be transferred by licensed gun dealers before the required background checks have been completed. In most cases, a licensed gun dealer receives notification within a few minutes from the NICS system that a prospective buyer has passed or failed a background check. In a small percentage of instances, NICS examiners may require additional time to complete the background check if information is missing or unclear in a prospective buyer's record. In other words, if the record shows that someone was arrested for serious crime, but doesn't show whether that person was subsequently acquitted or convicted, you would obviously have to make further inquiry, and you wouldn't complete the background check in 90 seconds. But it's that kind of instance where we should be particularly on guard. However, under current law, a licensed gun dealer conducting a background check on a prospective purchaser is permitted to sell the firearm to the purchaser if there's been no determination from NICS after 3 business days, even though NICS has not indicated that the person has actually passed the background check. Often we refer to this as a default proceed transactions. These are the very cases that ought to be investigated. In 2017 alone, the ATF determined that over 4,000 default proceed firearms transfers went to purchasers who could not lawfully own a firearm and should not have been permitted to purchase one. If NICS is unable to return an instant determination, and especially if there is no report after 3 days, there is cause for concern. One notable example of the tragic consequences of this loophole is the hate crime murder of 9 people at the Emmanuel African Methodist Episcopal Church in Charleston, South Carolina in 2015. In that tragedy, the shooter was not legally allowed to possess a firearm as a result of drug charges, but he still was able to purchase his gun from a licensed dealer who made the decision to transfer after 3 business days that elapsed, despite not having received a definitive response from the background check system. The bill before us today, H.R. 1112, would strengthen the background check procedures federal firearms licensees or dealers must follow before selling or transferring a firearm. Under this bill, the initial period a gun dealer must wait for an answer from the NICS system is extended from 3 days to 10 days. If after 10 days the NICS system has not returned an answer to the licensed firearms dealer, the prospective purchaser may file a petition with the Attorney General, which should help resolve most applications in short order. If an additional 10 days elapses without a response from the NICS system, the licensed firearms dealer then may sell or transfer the firearm to the prospective purchaser if the dealer has no reason to believe that the purchaser is prohibited from obtaining a firearm under federal, state, or local law. No reason to believe that is, aside from the fact that they haven't gotten a background check. H.R. 1112 is a sensible and necessary approach to address this issue. And I commend our colleague, Congressman Jim Clyburn, the distinguished Democratic whip, for introducing this bipartisan bill. I strongly support both H.R. 1112 and H.R. 8, and I urge that the House take up these bills and pass them without delay. Thank you. I yield back.
Thank the gentleman, and I'll please recognize the distinguished ranking member of the Judiciary Committee, Mr. Collins. I kind of feel like I should offer whether you want to testify there or up here, because you've been a member of this committee for so many years. So we welcome you back.
Thank you, Mr. Chairman. It is good to be back. I will say it's different on coming back now and coming from this side, but it is good to see my friends on both sides of the dais changed over. Chairman, Governor, Ranking Member Cole, thanks for having this and being a part of H.R. 8 and H.R. 112. For many years, the Judiciary Committee has prided itself on being able to agree to a fair process and full debate, even when we disagree on the substances of the matters before us. However, the committee's meeting on these bills marked a radical and alarming departure from that open process. Now, let me make very clear. Chairman Nadler and I have a great relationship, and we've worked on many things before. My criticism is about a process, not a person. And when we understand this, we have many things that we're going to be before this committee, because I know the chairman's leadership is going to bring a lot of bills that we are going to disagree on, but they're going to come forward because he's the chairman, and the chairman is, and the Democrats have bills they want to bring forward. But the process does matter, and this is a concern. So instead, I think that the use of a committee process which emphasized timing over quality and stifled criticism at the cost of full debate speaks directly to these pieces of legislation. Put simply, they're messaging bills. Had my colleagues harbored any intent that these bills be signed into law, they would have allowed a full and open process at committee to make sure they got it right. They may have, they may not, but it would at least been a full process. After permitting consideration of only 10 amendments to H.R. 8 on their merits, blocking another 3 on germaneness, the majority took the extreme step and they offered an amendment in the nature of a substitute in the middle of the markup for the sole purpose of cutting off debate. When my Republican colleagues sought recognition to offer amendments to the amendment in the nature of a substitute, the chairman refused to recognize them. Instead, he only recognized Democrats who moved the previous question on the amendment immediately thereafter. This step blocked dozens of amendments that would have exposed critical flaws in the legislation and, if adopted, could have made this bad legislation at least functional. Mr. Chairman, I think all of my colleagues would agree that these bills, whether you support them or oppose them, would constitute a massive and broad sweeping change in the law. I speak of these bills, H.R. 8 and H.R. 112, together because they are two sides of the same coin and will have a compounding effect on each. What concerns me just as much as the unprecedented markup of these bills is that my Democrat colleagues on the Judiciary Committee are claiming that they will actually impact mass violence that has been plaguing our country by passing this pair of bills, specifically H.R. 8. The sad truth is that if previously signed in law, H.R. 8 would not have stopped recent horrible incidents of mass violence in the country. This is why I have offered the Mass Violence Prevention Act as a floor amendment to H.R. 8. While I realize it may not be germane to the underlying bill, the MVP Act directly addresses the challenges law enforcement of coordination and response. It would reduce the flow of firearms into the black market, where most criminals get their weapons, and would bolster law enforcement's ability to prosecute criminals for firearms offenses. The MVP Act responds to the causes of mass violence. If reducing gun violence is the concern, the MVP Act is the legislation we should be considering today. But instead, we're considering a combination of bills that will do nothing to stop the proliferation of violence in this country, bills that have been poorly conceived and were barely considered at committee and are simply not ready for prime time. Bills should be reported by the committee and go to the floor when they are ready. They should not be deemed ready simply because doing so would make for a more convenient floor schedule. The only way to rectify the substantial defects in committee, short of sending them back to committee for a proper markup, is to adopt a rule that will allow consideration on the floor of all germane amendments. And for that reason, I respectfully request that this committee adopt a rule making an order all germane amendments to H.R. 8 and H.R. 112. And with that, Mr. Chairman, I yield back.
No, and I appreciate your testimony. Oh, yeah, Mr. Nadler.
I'd just like to comment on the process of the committee.
Go ahead.
To know what we're talking about. Committee convened at 10 o'clock in the morning, and except for recessing for votes for about an hour, I suppose, took no lunch, continued in session till after 9 o'clock at night. We made clear at all times that we were prepared to hear amendments in priority order. We were prepared to block vote them. We were prepared to do anything to expedite the process. We did make clear that we wanted to finish consideration in the day. And when the ranking member told me, I asked him how many amendments you have, he said 90. 90 left. It means more than 100. I concluded, and by the nature of the amendments, that what we were faced with were dilatory tactics designed to just keep us there forever, and not actually. I mean, there are reasonable amendments you can make to this bill. Not that many, but 90 amendments. Yes, I hated to move the previous question, but we did because we concluded it was totally dilatory and for no other purpose. And we told the minority, if you have important amendments, let us know and we'll consider them if they're important. But all we got 90 amendments.
Mr. Chairman.
Mr. Collins.
As well. And look, I appreciate the chairman's point of view. If I was the chairman, I'd have that point of view as well. The fact of the matter is that in the previous Congress, we moved a fixed NICS bill, which actually did pass and was signed. And we considered 6 amendments on the merit, 4 Democrats and 2 Republican amendments, and they were accepted. It's interesting to me that was the previous question moved last session. This came up. It was moved twice. It was actually on resolutions of inquiry. Never before did the Goodlatte move a previous question on substantive piece of legislation. In fact, I'd like to enter for the record a letter signed by the current chairman and a member at that point last Congress, and it was expressing our concern to move the previous question on H Resolution 488, resolution of inquiry that was put forward. And it was interesting is that what was said, and this was just September of 2017, it says, we say this for several reasons. First, we believe our actions are inconsistent with committee precedent. previous chairs rarely, if ever, chose to call previous questions during committee markup. During his tenure as chairman, Ranking Member Conyers never cut off debate in this manner. And there are a handful of isolated instances. I think the interesting issue here, and we can continue on this path, I think what is disturbing to us is the committee brought forward a bill that was as introduced. So there was no previous question, or there's no question moved when it's brought forward in that fashion. We did have a lot of amendments. The reason you have amendment debate and the reason you have this is so that the amendments are either debated on their germaneness or their relative use, not a decision that we've done too much. And when I was asked, and I did ask, why are we doing this? I was told many times by the chairman and other staff that we have to do this now. We've got to finish today. That was the answer given to me. Not that the amendments were dilatory, not that the amendments had no merit, not that the amendments couldn't be debated or talked. And I understand wanting to move the bill. That's not the issue. But when the amendment was told to me, the reason is we have to do this and finish this tonight was a concern. We stopped at 7:30. We took the other bill up and it lasted till 9 o'clock. So both in together. This is a concern because I do believe the chairman and I are going to find a lot of things that we're going to disagree on and agree on. But I don't want to see this go forward, especially with big pieces of legislation in which there is no discussion in between except a timing for a calendar. So with that, Mr. Chairman, I yield back.
No, and I appreciate that, and I appreciate the statements from both of you. Let me just say about process, and I say this with respect to my friends on the Republican side. It's a little bit too soon, I think, for you to complain about process. I mean, I sat on this committee here in the minority for many, many years, and on this very issue of sensible gun safety legislation, background checks, I think I lost count how many times we tried to offer an amendment to be considered on the floor so we could have this debate, and we routinely turned down. You know, I get it that you know, nobody wants to have any debate cut off or any amendment cut off, but I mean, going for 10 or 11 hours and then having another 90 amendments on a bill that is basically pretty simple in its focus, which is to, you know, close loopholes that allow guns to go to people who should not have them, like people with a violent criminal history or a history of severe mental illness. It would appear to an objective observer that maybe there's some dilatory tactics at play. But having said all of that, I appreciate you being here, and I yield to Mr. Hastings if he has any questions.
I don't have any questions.
Mr. Cole.
Thank you very much. Mr. Chairman, I'm going to disagree with you a little bit. It's never too soon to worry about process, particularly in a committee. There's a big difference between what we do here and going to the floor and what happens in committee. I serve on the Appropriations Committee. We accept every amendment on the Appropriations Committee. It doesn't matter how long it takes. It doesn't matter how many are offered. You know, I've sat through bill after bill, because we do 12 of them, where my friends in the minority offered, you know, extraordinary numbers of amendments, 50, 60 amendments. Fine. You know, that's actually one of the things that, in my view, the committee's set up to do. Again, this committee is, you know, a little bit different than what my friend Mr. Collins is talking about within the committee itself that is responsible for fashioning the legislation. Having, it seems to me, the maximum amount of debate is a good thing. Just for the record, because my friend went through this in some detail, my friend from Georgia, just a couple of quick questions. You know, when we did Fix NICS, was there a PQ announced or exercised in that?
No, there was not. And I think the other issue, we did another bill last year that was Concealed Carry Reciprocity Act, in which we did 18 amendments that were that the Democrats offered, all on their merits. And I think that's the only difference I'd have with the chairman here is up here, as I've sat on this committee and worked with what y'all have to work through, and God bless some of you who are new back on this committee now, you're going to have that. But in the committee process itself is a little different. And that's why it was a concern to me. That's why I raised it then. And this was offered. And this committee is not unheard of for going multiple days on bills. Even in the last couple of days, there's been days that we have stopped, we've offered amendments, and we've actually went on to the next day. The concern here was not an issue of, frankly, dilatory. It was, frankly, the issue that it was decided this was the week that this needed to get on the floor. I understand that. I respect the honesty. I just disagree with it.
I think that's an important point to make here. It's not this obviously not our jurisdiction. It's your jurisdiction, Mr. Chairman, what happens in the committee. But As a rule around here, very seldom have I seen PQs offered in committee to shut down debate. Most of the time, even when my friends were upset about what might be going or not going to the floor through this committee, the committee itself had dealt with every single amendment. At least the committees that I'm on generally did that. Mr. Chairman, let me ask you, I understand, and I want to be sure that I'm correct in this. I might not be. But I understand that after an amendment in the nature of substitute was offered in the middle of debate, the amendments to H.R. 8, Mr. Shabbat was not recognized for the purpose of offering an amendment to the substitute, and then the PQ was moved immediately after two Democratic members gave remarks. Was the amendment in the nature of a substitute shared with the committee or the public prior to the start of the markup?
The amendment in the nature of a substitute was identical to the underlying bill and was offered purely for the purpose of making a motion on the previous question in order after someone on the minority side had mentioned earlier in the day, I think it was Mr. Sensenbrenner, that a motion on the previous question would not be in order because an amendment in the nature of the substitute had not been offered.
Okay, and Mr. Chairman, I understand that during consideration amendment of H.R. 8 offered by Mr. Stube, the vote was called before the debate on the amendment had concluded. And in fact, calls by the ranking member and Mr. Biggs, the additional members wished to be recognized were ignored. Is that true?
I frankly don't remember if other people sought recognition, but there had been quite a few speakers already. And as you know, it is the prerogative of the chair to call the vote at any time. A member can speak for an amendment only if he's recognized for that purpose.
I certainly respect that power, but as a matter of courtesy, it's almost always extended.
I agree with that. And I'll be very frank. We had concluded, I mean, a bill like this is a simple bill. You can agree with it, or you can disagree with it. You can make some changes to it, a couple of exceptions here or there, et cetera. But 90 amendments, and you saw the nature of the amendments. Some of them were very picayune. We judged it as purely dilatory, and I said we're going to finish today. And that's why we had not, I will say, contrary to the ranking member's memory, previous question was used, I think, at least 4 times last year. I was very unhappy that it was used. I was outraged, in fact, that it was used. I didn't anticipate using it at all. That's why the motion, that's why an amendment in the nature of the substitute was not offered to start with. But when you see an amendment, the bill had gone on, and every amendment, no matter how minor, there were some major amendments, and they got fair debate, but there were some minor ones that got extended debate, and every amendment, no matter how minor, was getting extended debate. And we're told there are 90 more coming. The conclusion could only be that the only purpose was dilatory, and that we had to take action, and that's why we introduced the amendment in the nature of substitute, so that we could be in the position of moving the previous question. And we didn't do that till I think it was after 7 o'clock at night already, 6:30.
If I may, Mr. Collins, does that accord with your memory or recollection?
Look, no, I think what you offered was exactly true. We cut off debate, and it is in the chairman's prerogative. If he wants to call a vote, he can. And I understand. The interesting thing, though, is go back on this issue is, again, goes back to timing. Judiciary Committee typically handles very emotional, very long, very detailed debates. If we want to talk dilatory, we did over 7 hours of debate on the committee rules last Congress. 7 hours of debate on the committee rules. And we took amendments. It was just on and on and on and on and on. And Chairman Goodlatte at the time sat there and we went through the entire thing. We did, 8 hours plus on resolution of inquiry that was ended on a previous question. The question here really is 90 amendments. And I've said in the committee as well last year under bills that we brought up in which I knew that they were, far more than the amendments actually offered by our friends on the Democrats on the other side, but they just never got to them. Whether we had offered, all the bills that our members had came up with or amendments were probably not, I would have to say. But there were many in there that probably would have gotten at least 10 to 15, probably maybe even more, that should have at least got a hearing. So, whether you're just saying it was that, I can understand his concern, but it goes back to the very reason given to us. And I understand they had a timeline and the timeline was being kept. And that's why the amendment was brought. And that's why the debate was closed down. Again, setting for further on, and I agree with Mr. McGovern. We've had fights and debates up here about this all along. I think the difference for me, Mr. Chairman and Ranking Member, is the difference in the committee itself.
Let me
process.
If I may, let me say
Yes,
this.
certainly.
We asked, give us a list of 10 or 15 major amendments, the more important ones to you. We would have considered them, in addition to everything else we considered. All we got was that there are 90 more amendments, or 90 amendments. And we concluded it was purely dilatory. Let me say one other thing. For the last 4 years, maybe 6 years since the Republicans took control, the rules of the committee were amended so that subpoenas could be issued simply on the say-so of the chairman, unilaterally, after consultation with the minority member, ranking member. Consultation would consist of the chairman seeking me out on the floor and saying, here's a copy of an amendment, here's a copy of a subpoena we're going to issue. And I'd look at it and I'd say, that's a good idea, or that's terrible. Thank you, you've been consulted. And it would be issued. I voluntarily, as the new chairman, said, we're not going to do that. We didn't amend the rules, so we still have permission to do it. But we said, we'll do the same up to a point. That is to say, if we have a subpoena we want to issue, we'll show it to the ranking member. If he objects, we will then take it to a vote of the committee. We've issued, I think, only one subpoena so far, and that was done after an extensive, what? It probably won't be the last one, but that was done after an extensive debate because the ranking member objected to it. And so we had a markup. We spent the whole afternoon on it, I think, because we respect the right of the minority. We're going to issue more subpoenas, and I hope to follow the same procedure. We're not trying to ram anything through, but we are going to insist that if it appears totally dilatory, a raft of picayune minor amendments just designed to eat up time, at some point we'll say enough. We'll ask first, do you have a list of the important amendments that you regard as important? We'll take them up, but not if there are 90 of them.
Yeah. And Ms. Cole, if I can follow up. Look, I think as every member up here, the eye of the beholder is their own amendment. And every member who has an amendment would consider that to be important to them and not dilatory. And I think for have a decision made like that. And also, I will commend the chairman. In fact, after we had our rules, man, we did this and had the consultation. I actually issued a press release commending our chairman doing that. These are the ways we can work on this. We have a disagreement here. It showed up in this first major hearing. And, we brought that forward. And I think, whether amendments are made in order here, Mr. Chairman, we'll follow that process. I would hope to think that if you made 5 amendments or 10 amendments or no amendments, whatever it may be, they would not be considered dilatory. I think this is a process that we work through and we move into that. But Ms. Scott, and again, where we can find work, we'll work. We just disagree on this issue.
Well, I hope that I have great respect for both of you. I have great respect for your committee, although listening to this makes me very happy I'm on this committee. I hope you can work through this because I really do think, sadly, I think the way things have evolved in this institution over many, many years, committee process is the fullest, fairest, most complete airing, and usually in front of people that in our body are the most knowledgeable about what they're listening to. They're the people who have gone through the hearings. They're there for a purpose. They build up institutional expertise. So I would hope that going forward that this would be a very rare item. I know the chairman would probably want that as well, to use a PQ in committee. Mr. Chairman, before I yield back my time, if I may, I'd like to enter in for the record the statement of administration policy.
Without objection.
And I also have some remarks from Mr. Rice from South Carolina, who was unable to come, that he would like entered into the
Without
record.
objection.
Thank you very much, Mr. Chairman. Yield back.
No, and thank you very much. And again, I wish you the best as you move forward in the Judiciary Committee. But I do want to remind my colleagues that we've had bills come before the Rules Committee that were Judiciary Committee bills that bypassed the committee entirely, that didn't even have a hearing or a markup. And I do want to remind everybody that we are here to talk about keeping guns out of the hands of violent criminals, not to talk about keeping arcane procedural motions out of the hands of committee chairmen. So, I think this is a little bit of a distraction from the the topic at hand, but I will now turn over to Ms. Torres if she has any comments.
Thank you, Mr. Chairman. And I was going to say exactly the same thing. I mean, we've been at this now over 35 minutes and have not talked or said a single word about the victims of gun violence and why we are here today. And that is, most unfortunate to me, that we could continue to gum up a very important piece of legislation on a process that simply, when we were in the minority, we were incredibly disrespected each and every single time when it came to following a process, when it came to taking up any of the amendments that we had. So I want to talk about the bill. I want to talk about how we can help stop this terrible epidemic of gun violence in our communities. I want to ask you a question, Mr. Chairman. Last Congress, you were the ranking member of Judiciary Committee. And how long were you the ranking member of this committee?
About a year.
Okay. And previous, how long have you served on that committee?
26 years.
26 years. In that 26 years, let's just take the last 10 years. How many times have you seen a gun bill come before your committee?
We haven't had a hearing on guns in over 8 years. The only bill that came before the committee in that time period, to my recollection, was the bill that would have made things worse, was the concealed carry bill that the Republicans wanted, which essentially said if you had a concealed carry permit in state A, you could carry that into state B, even if you didn't meet the requirements of state B's law.
So just to try to keep things simple here, this issue...
We also did the fixed NICS bill, I'm reminded.
This issue has not been a priority to have a hearing about how we can work together in a bipartisan way, Republicans and Democrats, to answer the cries of the parents and the grandparents and the family members of the people that have perished in our communities as a result of gun violence. I mean, I think that we've heard a lot about the mass shootings. What we don't hear about is the little girls and the little boys and the people in our communities that fall victims of gun violence every single day. You know, those names will never be heard. Their voices will never be heard. So here we are. I want to thank you for, what was it, 10 or 12 hours committee hearing that you had?
10, I think.
10 hours? Okay. 10 hours on these two bills. Can you tell me about the approach that you took to ensure that this legislation had the right tone and your effort in trying to get bipartisan support on these bills?
Well, as you know, these are not new bills.
No.
And there's been a widespread effort for years to get bipartisan support. These are mild bills. I mean, they are not the bills which I think we ought to pass, but to ban assault weapons or ban large capacity magazines and things like that, which we may take up later in the session. These are bills which we think, with a lot of pressure, may get through the Senate. That's why we took them up early. May, I stress, I don't know. But we think they have a shot. And obviously, there's been a major campaign behind them. As I said in my opening statement, 90% of the American people support the universal background checks bill. We had 5 Republican co-sponsors of this bill, of H.R. 8. And we scheduled a hearing and then a markup. We had a full day hearing on the gun bills about a week before. First hearing, as I said, in many years on guns. And then we scheduled the markup. That's what we did.
Congressman Thompson, as you know, California has some of the strongest gun violence legislation in the country. But yet we still have a problem with illegal guns that are being trafficked into our state. from bordering states. How would this legislation help? Can I, well,
This legislation will not solve all the problems. It will go, we think, a long way. Basically, it will mean that you can't transfer a gun to someone without that person having, with some exceptions in the bill, without that person having passing a background check. Right now, if you want to purchase a gun at a licensed gun dealer, you have to pass a background check. But if you get it at a gun show or by other transfer, other than by a licensed dealer, you don't have to have a background check. This will close that loophole, basically. And the companion bill will close the loophole of automatically getting the background check, automatically not needing the background check if it isn't completed in 3 days.
and internet sales?
Internet sales would be subject to this.
Thank you. I'm going to yield back.
Thank you very much, Mr. Woodall.
Thank you, Mr. Chairman. I take your point that it might be too soon for my righteous indignation about the process. I just would say that it's not too soon for you to put 8 years of your righteous indignation to work here, right? There's no reason to delay fixing what folks have accurately described as a problem. And I've been focused on this all year. I think the majority is making a terrible mistake, taking things that could be bipartisan and turning them into partisan bills. And I put trying to fix the NICS system into that category.
Well, gentlemen, you know, just for a second. Yeah. So just so you know, under the rules, hearings or markups aren't even required yet. But in this instance, they were complied with, and this is a bipartisan bill. And Mr. Thompson, who is here from California, is the author. And I think Mr. King of New York is 5 Republicans. So it's not. I just wanted to clarify that.
I have thought about bringing my countdown clock to the floor of when those new rules are going to go into effect.
I think we're doing
those two.
We're not doing so bad.
I have given the chairman credit for that over and over again, and I think it's a wonderful initiative. And well, tomorrow always begins today. But Chairman, this committee opened with we're taking up this bill to save lives. I don't recognize that as a partisan goal. I recognize that as a shared goal that we all have. I was pleased to support Fix NICS when it passed the House twice because it makes no sense to have a background check system. Background check system doesn't work. Let's make it work better. I read the legislation though, and I come from a gun-owning family. My mom taught me to shoot. Her dad taught her to shoot. We go out, aunts, uncles, cousins. We're all out together on the family farm. And my reading of this bill says that the 410 rifle that my uncle gave me as a gift as a child, that uncle to nephew transfer is no longer permitted in America. And that my uncle would either have to go to a federal firearms dealer and pay to have that transferred, or my uncle could give it to his sister, my mother, and then my mother could give it to me, and we could go around the rules. But there is no exception for aunts, uncles, cousins, those family members. Am I misreading that section of the bill?
No, I don't think you are. There are exceptions for family members, for certain family members, not for uncles and aunts. Transfer, this is the exception here? I'm sorry, it is. The exception is a transfer that is a loan or bona fide gift between spouses, between domestic partners, between parents and their children, between siblings, between aunts or uncles and their nieces or nephews, or between grandparents and their grandchildren. That's an exception to the bill.
And those transfers would not have to go through an FFL dealer at all.
That's right.
Now I'm looking also at the section on
Cousins would. Mm-hmm.
Looking at the section on loans of guns. My dad's friend Gary gave him a .243 bolt action for deer hunting back when I was a kid. When my dad passed away last summer, he still had that .243. Gary's got so many guns, he didn't need it back. that's been a 30-year transfer. If my dad's best friend wanted to sell him that rifle instead of loan him that rifle for 30 years, that would be a transfer. Now that we go to a gun dealer to do, I can no longer, in my hunting club, I can no longer sell weapons back and forth. It becomes an FFL issue. Okay.
Yes, the purpose of the bill is to make sure that when someone new gets a gun,
Right.
the background check is done with some exceptions. But we don't want the exceptions to overwhelm the rule.
But and the committee concluded that not having that exception broadened, that not allowing me to sell guns within my hunting club, that's folks expect that to save lives, not just to create a burden on legal gun owners, but it's going to make a difference as in the committee's judgment.
Well, I'm not sure what you're talking about within the gun club. There is an exception that says, while reasonably necessary for the purposes of hunting, trapping, or fishing, if the transfer has no reason to believe that the transferee intends to use a firearm in a place where it is illegal, and has reason to, that is the transferor, has reason to believe that the transferee will comply with all licensing and permit requirements for such hunting, trapping, or fishing.
I believe that's a temporary transfer section that you're reading, not a permanent transfer.
That's correct.
I'm thinking about ways that we can work together to save lives, preventing transfers of folks I've known for 40 years back and forth is not going to save any lives. It is going to make some money for somebody in the process. It is going to make it convenient. Did the committee think about going the other direction? I know it was passed in a bipartisan way back in '86, but when we changed the '68 Act to say that an FFL dealer isn't someone who trades more than 4 guns a year, but is someone who makes their livelihood off selling guns, seems like we could have gotten to where the committee wanted to go by looking at some very general language like the '68 bill. Is that
I'm not sure what you're saying, what you're proposing.
My shared goal with the committee is getting guns out of the hands of folks who would do harm. The committee
making sure they don't get the guns in the first place.
That's exactly right. Committee has gone out of its way to put in line after line to say, for all of these temporary transfers, for example, if you believe this person that you're transferring it to is a good person and they're not going to use it for bad purposes, you can go ahead and make this. While
reasonably
transfer
necessary for the purposes of hunting, trapping, and fishing, you might convince me, if you keep talking this way, that we should remove that exception.
I take the gentleman's tongue-in-cheek comment.
No, it's not tongue-in-cheek. The purpose of the bill is to say we don't want firearms transferred without a background check. We will agree to certain exceptions. I'm not sure we should agree to those exceptions, but we're being okay with that. We're agreeing to exceptions where reasonably necessary for hunting, fishing, if you believe the person's a good person, etc. Maybe we went too far with the exception. I certainly wouldn't want to go farther.
Well, I suppose then that's why we don't have a broad bipartisan support. I go back, I look at the '68 Gun Control Act. It passed with a majority of Democrats and a majority of Republicans supporting it. I look at the '86 revisions, a majority of Democrats and a majority of Republicans. Perhaps that's what you expect to see tomorrow. It's not what I heard from my ranking member.
I certainly hope so. We have a number of Republican sponsors, as has been mentioned, and this bill, this concept, is supported by 90% of the American people in poll after poll after poll. And it's a simple thing. It doesn't say you can't have a gun. All it says is, with some exceptions, you got to have a background check, period. We want to be a little safer, that people who are homicidal maniacs or mentally unstable or whatever shouldn't have guns. And we put in some exceptions. But we don't want to go too far with the exceptions. And again, this isn't terribly burdensome. All it says is get the background check. Now, the only objection I've heard, other than the fact that you have to take some time to if you're not buying it from a licensed gun dealer, which is what the bill applies to, what are the objections? What are the possible objections other than we don't like it? One, you're going to have to take the time to go to a licensed gun dealer and get checked out. That's a bother because it takes some time. Well,
And money.
What?
And money.
I'm coming to that.
Oh.
I said there were two. And second, it'll cost some money. Yeah, it'll cost some money. How much? I don't know. The market will determine that. Republicans don't like that piece. Basically, the licensed gun dealer will charge you a fee for doing this. Of course, if the gun dealer around the corner charges a lesser fee, that becomes known. You probably go there. So there'll be market pressure to keep the fees low because there are twice as many licensed gun dealers as post offices. And yes, there's a slight burden, but our judgment is that it's worth that burden to keep guns out of the hands of people who shouldn't have them, to a large extent, not perfect. And again, remember what we're dealing with. Other countries have 150, 175 people murdered by guns a year. We have 39,000. And no one can tell me that Americans are 10,000 times as mentally ill as people in Europe or Japan or anywhere else. The problem is the prevalence of guns in our society. This is a very mild bill. I would, if I could, go much further. But this is a very mild bill to say at least we'll get a background check with some exceptions. And yeah, it'll be a slight inconvenience. And yeah, there's a cost. Of course, you got to buy the gun. I don't know how much the gun costs. This will be a slight addition to the cost of the gun. So what?
I went back and read some of that debate from 1986 when we were changing the definition of what a federal firearms dealer was. And I know my colleagues on this side of the aisle do not agree with me on going back to an earlier definition. But I am concerned that your definition of a mild burden is another person's definition of time and money and expense for something that's not going to save a single life. It's not going to make a single difference. You raise your eyebrows. I know you're not thinking about me and my family and my friends and the transfers we're talking about. I promise you, there's not a bill you're going to pass that's going to influence
but
the law.
You're going to pass the background check. And your family's going to pass the background check, I presume. It's the guy who can't pass the background check. We had a statistic somewhere, I think it was in my statement, that 22%, I think it was, of people who take the background check, fail the background check, and thus we keep guns out of the hands of felons, mentally unstable people, and so forth.
It's not in the bill. It's referenced. Could one of you tell me what that new penalty is for selling that gun to a friend, selling that gun to a non-accepted family member? What is that new penalty?
The penalty for violating the bill and selling a firearm or transferring a firearm without the background check is up to a year.
Up to a year. It's a misdemeanor.
Well,
Okay.
by definition, if it's up to a year, it's
Sure. There. I thank you both. I yield back, Mr. Chairman.
Mr. Promoter.
Thank you, Mr. Chairman. Gentlemen, thank you for your testimony today. I happen to serve also on task force, gun violence task force that we put together. And I can say, Mr. Collins, that we begged for hearings on universal background checks for 8 years. We actually held a hearing ourselves because we couldn't get anybody to take it up. So I appreciate Mr. Nadler, the Judiciary Committee's willingness to take up universal background checks. And I want this to be a universal background check. So unlike Mr. Woodall, I want to see it cover as many people as possible and those individuals who don't have anything to hide. Because, and I want us to take advantage of the fact you did fix NICS. And we have better information, more accurate information, more available information. I want to see us to be able to use that. And this bill allows that. And those people who have no issues, no felonies, no severe mental illness, fine. They're going to be able to have a gun transfer, no problem. But those individuals who, for whatever reason, are picked up by that NICS system, we're going to slow it down. And in my opinion, and after, Colorado, we faced a lot of gun violence. not so much the day-to-day stuff, but certainly the mass shootings. And I wholeheartedly support this. I do think you're being very reasonable in the exceptions that have been allowed so far, and I hope we just move this thing forward. With that, I yield back.
Thank you. Mr. Burgess.
Thank you, Mr. Chairman, and thank our witnesses for being here today. Just on the issue of the process, little less than 2 years ago, we had a committee hearing in our Energy and Commerce Committee dealing with healthcare. A lot of people were really excited about it. We had a lot of amendments that were offered, and we went straight through some 29 hours. Same time, the Ways and Means Committee went through 18 or 20 hours of the markup. Our former colleague Ralph Hall recalled to me one time that the markup of the Clean Air Act in the Energy and Commerce Committee took 8 months. So if it's truly important public policy, I mean, it can take longer than a day's work. And I just offer that for everyone's consideration. Oftentimes, if we don't have that process in the committee, we're the rest of the Congress is, if we short circuit it, the rest of the Congress, I think, suffers from not having exposure to the ideas and to the debate. Let me ask a question of Mr. Collins. You've introduced a bill called the Mass Violence Prevention Act that creates a fusion center focused on preventing violence through proactive information sharing. Was that something you thought of offering as an amendment to this bill?
We have. I mean, we understand, and again, we've offered several things in committee that we're considering non-germane. But I want to take off of and talk a little bit about that is being an issue that we come, because I agree with my story. The ones that are forgotten in this are the single shooting, what we see in Chicago, what we see in Atlanta, what we see in some of our cities. The issue, though, is not the laws that are there that would stop this. To start with, they're not being prosecuted, a lot of this. I mean, think about this for just a second. Federal law already bans transfer of a firearm or sale of a firearm to anyone who known or believed to be prohibited from possessing a firearm. It already is against the law for anyone with an FFL, who's a federal firearms licensee, from acquiring a gun outside their state of residence. It's already against the law. It's already against the law for anyone with an FFL from acquiring a rifle or shotgun from someone without an FFL outside of their state of residence. Individuals transferring a handgun across state lines to someone without one. These are all already against the law. An example is that you would see is just in Chicago alone, where we've had a lot of instances, is sort of like what you discussed, that one that gets overlooked, the ones or twos, or even the others. Even if the robust prosecution, the city and state only prosecuted 25 federal firearms crimes in 2011, and then saw 506 murders and 512. I agree completely that there's a problem here that we need to look at. My concern is with this bill is especially the way we had our hearings and others, and it's been many times, and I understand the concern here from all of our partners here, is mass violence. But this bill would have not stopped any of the major mass violence that we had testimony about, or any that we have seen from Columbine, back to Parkland. It would not have had on any of these, on any that we had looked at. What we're looking at on mass violence is a fusion center, which would have helped Florida, because it would have made sure that the signs that were missed were actually caught. It would actually take into account illegal street sales. It strengthens the penalty for burglary and robbery for federal firearms licensee on a retail store. It also goes into prosecuting, violent crime and clarifying that which is a clarification on 18 U.S.C. 924, that law enforcement can apply the statute for those intended to prosecute or deter violent crime. These are the kind of things that actually try to get back at what actually does work, and actually what we have seen, the prosecution. And I agree with the chairman. I don't think we're that much more mentally ill. I think the problem is in many of these areas, we don't see these crimes prosecuted. And we actually offered an amendment that was voted down, and hopefully they'll be made on order here, it's illegal to, if you try to buy a firearm illegally, you're supposed to have that reported. And we offered actually, we've seen it from even illegal immigration status is a part of this here, along with other issues that we have. These are voted down. The issue, though, that we have here, and going back to something that the chairman had mentioned, and I understand the concern on, doing a background check. It's not just the inconvenience, which is, for someone who owns many firearms and went through that and have a concealed carry permit myself. It's not an issue of the background inconvenience. The bill actually has in here, and there's some discussion about this, is the cap on this. It's not a problem in North Georgia. I've got 14 firearms dealers I can't shake a stick at them in my area. If you either got Baptist churches or banks or firearms dealers, we just have a lot of them. So it doesn't matter. If one is going to charge a lot, I'll just go to the other one. But in places that are rural, like Colorado, North Dakota, Alaska, even Washington, D.C., where there's one federally firearms licensed dealer, we got to take a look at. That's a monopoly. And they could charge whatever they wanted to charge on this. And when you get into states or maybe where it's not as popular to have firearms, the question becomes is what could happen there by pressure brought by others for have this amount. At that point in time, it keeps it out of folks who can't afford, they maybe could afford the gun, maybe that's a possibility, but then going for this next step could not. Again, and I would love to talk with Ms. Thompson. We see each other almost every morning anyway. This is a bill that actually hits to the law that's not being enforced. Judge, I think you probably saw that on the bench. These are just not enforced because they're hard, because the law that is on the books to enforce is difficult. But they're on the books, and just my question actually becomes, and this is a question mark, when we had the hearing, it said it'll save, at the end of the day, the police chief from Houston actually made a comment. It actually came to the help of the committee, and it was actually a good comment. He said, if it would just save one. I can't disagree with that. If it saves one, there's a thought here that can't save one. But my concern is would it actually put others in danger? And that was the flip side of this. By some of the concerns of the cost, some of the concerns that we're going through here. Would it put someone in danger? A domestic violence victim who has a TPO actually I could not let them borrow a gun if we knew it. There's other issues where this thing talks about imminence, that you can, if you're imminently thinking that something you're going to deal with a health risk, that I could give my firearms to my neighbor and that wouldn't constitute a transfer and wouldn't have to go through a background check. But what does imminent mean? Are we going again to trust the courts in this? This is why a hearing, even if it was 7 or 8 hours long or even 10 hours long, needed to be had. I want to find a fix for this. My father's a state trooper. I'm from a law enforcement background, but we're not seeing this stuff actually prosecuted. My question then becomes, if it will save one, great. But if we put another law on the books, and as the lady who is a very good witness from the Gifford Foundation, she said, when asked about this, how would you prosecute it? The answer came back basically was this, and I'd go back and read the transcript, I don't have it, but I remember what she basically said is after the fact, when a crime is committed, then we would know there was not a transfer made. That's the problem we're dealing with here. Because without some of the other issues in the bill itself, there's no way to actually follow up on this. And I appreciate the work being done. I just think that there's stuff like this, what I'm trying to do with the Fusion Center, with other, and also putting the resources to actually prosecute this is a better way to go about it.
So Chairman Nadler, let me just ask you a question about the Fusion Center. Do you think about the Fusion Center as Mr. Collins, Ranking Member Collins has described it? Do you think that is something that would be helpful to have a fusion center like the National Counterterrorism Center?
It might be. I haven't studied it. We certainly could take a look at it. But again, they're not exclusive. They're not mutually exclusive. And to argue against a bill that will clearly save lives, a bill that, research has shown that state laws requiring background checks for all handguns sales by point of sale and or permit are associated with 48% lower rates of gun trafficking in cities and 29% lower rates of gun trafficking across state lines, for example. We ought to pass this bill and look at other things. This bill will not solve all problems. It's a mild bill. It will not, if I had my druthers, I would ban assault rifles and magazines. Maybe Mr. Collins' idea is a good idea too. Take a look at that. But we ought to start, and this is the bill that has 90% support of the American people. Now it's the bill before us. And if there are other bills too, we'll look at them.
Yeah. Can I add something to that though? And the chairman is agreeing, but also some of the areas and states that have the absolute most restrictive gun laws on the books have some of the highest gun violence crimes. And granted, as has been pointed out, some of that is because they've either bought it from out of state or that's illegal already. So again, it's a concern. I understand the chairman's passion. I understand the need. We've had hearings on this. I think this is the difference that we have in this, is finding actually solutions that work.
So why aren't the prosecutions happening?
I think, you want to try, Mr. Chairman?
Well, I think some prosecutions are happening, but
Well, let me just expand upon that. I mean, the OIG report from a couple of years ago,
I'm sorry?
the Office of Inspector General report from a couple of years ago, not that too many years ago, it was in the last administration, but of people that were known to have lied on a background check, the number of prosecutions of that subset was infinitesimal. It was startlingly small. So if we pass this law and it were to be signed by the president, which I don't think will happen, how does that change?
Well, I think we would agree that there ought to be more prosecutions. If the numbers are as small as you say, there certainly ought to be more prosecutions. I would point out that appropriations for the ATF have gone down. There's a severe resource problem.
If I may just reclaim my time for a moment, the availability of funding through the Fixed NICS bill that was passed in the last Congress did in fact increase some of those grants.
It increased somewhat, but the fact is that there is much too small. You know, the prosecutors have a lot of things to do. And maybe the sort of these things arguably ought to be a higher priority on their list, but we have not properly funded the ATF. We ought to properly fund the ATF. And I would certainly agree that there ought to be more prosecutions, and that's a separate question as to why there aren't. But again, that doesn't argue against common sense improvements to the law such as this bill.
Yeah.
Well, let me just say, if I may, as Mr. Cole and I have this discussion all the time, you are the authorizing committee. You tell them what to appropriate. In a perfect world. As authorizers, we should give our instruction to the appropriators.
Yeah, and Mr. Bird, I want to jump in because my bill actually does that, authorizes 50 more folks on gun crimes itself. The other issue is, and part of this is I don't want to say desensitized or anything else, but we also have to say that former Vice President Joe Biden actually said probably some of these don't get prosecuted is because they're viewed as paperwork crimes. They're viewed as paper crime, not actually that you're attesting to something. And I think sometimes that we don't put it a high enough priority on the list. But these are actually the things that do affect when they're actually applied illegally and you're trying to get it around the system. It then pushes it to the other market, which is going to be even more difficult. But I think these are the kind of things that you do put resources and time and effort into as we go forward. I appreciate the chairman's concern. I just think we're just not catching the whole process here.
Well, we're not catching the whole process. This bill is a partial bill. I certainly am open to. I mean, remember I've been chairman of this committee, for a month and a half or something like that. And maybe we need greater appropriations, and maybe we should have more enforcement. I'm certainly open to looking at that, but it's not an argument against this bill. And it is very frustrating always to hear that we shouldn't do things that we obviously ought to do because the solution is better enforcement of the existing laws. This part of the solution may be better enforcement of existing laws, and maybe appropriations should be changed appropriately. But it's not an argument against closing huge loopholes in the law. We know that, I forget the statistic, it was in my opening statement, but we know that a large percentage of people who are applying for guns fail the background check. That means that they shouldn't get guns. And that also means, presumably, that if people who are buying guns through a gun dealer fail the background check, people buying guns online or at a gun show are probably going to also be failing the background check at a more or less similar ratio, which means that a lot of people who shouldn't get guns are getting guns. And whether we should enforce existing law more effectively or not is a different question. It doesn't bear on the fact we should keep guns out of the hands of the people who shouldn't have them.
Reclaiming my time for just a moment, because I know we've gone on long. I disagree that it's fundamentally a different question. If we're just going to pass laws and not care about the enforcement, then what in the world are we doing? And you have that, I don't know all the details about the shooting in Aurora, but the gentleman had a felony conviction for aggravated assault in a different state. He applied for and was given the permission to purchase a gun. And it was only when he went back and said, oh, I really would like to get a concealed carry permit, that they submitted his fingerprints and found, oh my gosh, you're not even eligible to own the darn gun. Please bring it back to us. And he never did. And the next time you hear from him is after he's committed this terrible atrocity. So I submit that the enforcement does matter. And if we're going to pass laws, we ought to be concerned about that. Let me just stress one other thing, because I do have, constituents complain that we do stuff that restricts their rights. And at the same time, when it's the federal government that it's the problem, we seem uninterested. And I have here an excerpt from the Marjory Stoneman Douglas High School Public Safety Commission, the report submitted to the governor, Speaker of the House of Representatives, Senate President of Florida. And I'll just concede, it was a lengthy report. I encourage people to read it because it's very revealing. But Chapter 8, the summary of the shooter's life and contacts prior to February 14, 2018, prior information received by the FBI regarding the shooter's behavior. It was widely reported and confirmed by the Federal Bureau of Investigation soon after the shooting that the FBI had previously received tips concerning the individual who did the shooting. The first was received on the FBI public access line on September 25, 2017, from Ben Benight in Mississippi. Mr. Benight, who was unknown to the shooter, reported a video on YouTube stating, quote, "I'm going to be the next school shooter," close quote, made by a user identified as Nicholas Cruz. The information was forwarded to the Mississippi FBI office for follow-up, and the tipster was interviewed. However, it was determined there was not enough information to positively identify the poster of the video, and the tip was closed on October 11, 2017. Efforts to serve legal process on YouTube or Google that could have identified the poster were not made. The second call came to the public access line January 5, 2018, by a friend of the Cruz family, Mary Hamill. Ms. Hamill had become increasingly concerned about postings Cruz was making on Instagram and feared he would actually follow through on threats to harm others by perpetrating a school shooting. During the 13-minute phone call, Hamill provided details of Cruz's gun purchases, animal mutations, escalating temper, and Cruz's Instagram usernames. The names, addresses, and phone numbers for the Sneed family were also provided, which was the residence where Cruz was residing at the time due to the death of his mother. After some initial searches by the call taker, the tip was closed after it was labeled as having no lead value. It is not clear at this time exactly why the lead was labeled as having no value and closed without being forwarded to the FBI for further evaluation. It is this type of information that is out in the public domain. I took this off of a Google search. It is this type of information that's out in the public domain that is so frustrating to the public. They see us saying you cannot have full access to your Second Amendment rights, and yet the federal agencies, and there were failures all up and down the line in this situation, but the federal agency that's responsible for protecting the public and enforcing the law simply could not be bothered to follow through. Thank you, Mr. Chairman. I'll yield back my time. I do want to, if I could, insert this for the record.
Without objection. Scanlon? Make sure your mic is on. Yeah.
I know there's been a suggestion this bill has been rushed, but from my constituents' perspective, it's long overdue. 2 weeks ago, in a 6-day period, there were 6 shootings in my district. 4 people died, 2 were critically injured. The oldest was 28. The rest were 16, 17, and 18 years old. So my constituents are saying, why aren't you doing something? And I'm glad to know that we share a heritage of families who own guns and hunt, because I grew up in that family too, but it was responsible gun ownership. And you know what? I've got some cousins that I want a background check run on. It really is not that big a burden. I think we really need to take this step forward. I agree with Chairman Nadler that this isn't the bill that I would write. The one I would write would be more restrictive, but we have to compromise. That's what we're here to do. So there are things in this bill that would not be my first choice, but I certainly don't see any Second Amendment restrictions. With respect to Mr. Clyburn's bill, H.R. 1112, I just want to read a quick thing from an article in the Wall Street Journal from last week, February 19th. The article is entitled "Armed and Dangerous: How the ATF Retrieves Guns from Banned Buyers." Mr. Chair, can I enter this article into the record?
Without objection.
Okay. Just quickly, the article says current and former federal officials say the 3-day time limit doesn't give FBI examiners enough time to perform a thorough record search. That is the single most influential factor that could be changed without affecting the whole integrity of the process, said Stephen Morris, the former FBI assistant director who oversaw the background check process. So our own federal officials are saying they need these tools. So, I'm looking forward to passing both H.R. 8 and H.R. 1112 and to working in a bipartisan manner on many of the things that Mr. Collins has suggested, looking at mass shootings. We're hearing from some of the other gentlemen here that they want to work on better funding for ATF and better enforcement. I'd love to work on all of those things. So thank you. I yield back.
Thank you. And I'm going to ask unanimous consent to insert in the record a statement from the Giffords Foundation entitled 50 State Analysis Shows Lower Rate of Gun Deaths in States with Strong Gun Laws. And then also insert in the record an article that appeared in Vox, which I'll share with my colleagues, entitled, "I looked for a state that's taking gun violence seriously, and I found Massachusetts." And it talks about how Massachusetts offers a model for dealing with gun violence that the rest of the country should follow. Indeed, Massachusetts is one of the lowest, gun violence rates of any state in the country. And I'll yield to Ms. Shalala.
Thank you very much, Mr. Chairman. I will be brief. I also come from a family of gun owners, some of whom live in North Dakota, and they're hunters. We see this bill as a prevention bill. I worked on the Brady bill early in my career, and this closes many of the loopholes that we weren't able to close at that time. In my state, Florida, and particularly in South Florida, closing loopholes like gun shows and internet sales are absolutely critical. This is an important bill. It's a promise I made to those young people from Parkland that I would do everything I could to support. I believe that I can support this bill as well as believing in the Second Amendment, but more than anything else, it's a bill about prevention. And if it prevents one death, it's worth it to me because of my conversations with those young people and their parents and the other children in my community that have been killed by guns that were purchased because of the loopholes that exist before. So I strongly support this bill. Thank you, Mr. Chairman.
Well, thank you very much. And I want to thank both of you for being here and appreciate the time you spent with us. And you are now free to go. It wasn't quite 11 hours. I'd like to call up our next panel, Mr. Gianforte, Mr. Armstrong, and Mr. Klein. Just why don't you pull up the, watch out, you'll be one panel here. Mr. Thompson, do you want to speak? Or you're okay? Just hanging out. Let the record reflect that Mr. Thompson from California is here, author of H.R. 8. Just pull up another chair. Yeah. Mr. Gianforte, why don't you go first?
Great. Thank you, Chairman McGovern and Ranking Member Cole. I appreciate the opportunity to speak to you regarding amendment to H.R. 8. Our communities face tragic instances of mass violence. My wife, Sousa, and I hold the victims of violence and their families in our prayers. We need to work together to combat all forms of violence. H.R. 8 seeks to be a solution. I appreciate that. I don't believe it solves anything, however. Our country already has strong background checks and transfer guidelines. This bill's wide scope puts law-abiding citizens in the crosshairs. Simply put, this is a bill is an irresponsible attempt to criminalize lawful gun owners. H.R. 8 is another example of a Washington knows best approach that ignores the realities that folks in our rural communities face. My amendment allows farmers and ranchers to transfer firearms to their employees or neighbors for the purposes of ranch activities. These activities include pest and predator control, hunting, target practice, and firearm safety courses. My constituents own and operate ranches across Montana. In many of these counties, we have more cattle than we have people. Many of these ranchers employ ranch hands to help run these ranches, and they often have neighbors help them to pitch in with chores. Most trucks on these ranches have firearms that are owned by the rancher. Like so many ranchers and farmers throughout Montana and across our country, they equip their trucks with firearms so that workers can quickly and effectively address the constant threat of pests and predators. If an employee of the ranch drives the truck equipped with a firearm, H.R. 8 would consider this activity an illegal firearms transfer. The bill as written requires employees or neighbors just helping out to undergo a background check and paired with a 3-day waiting period. Predators and like coyotes and wolves don't care about a 3-day background check when they're hunting their next meal at the expense of the rancher's livelihood. It's absurd to require a background check on every transfer of a firearm between a ranch owner and a neighbor or a ranch hand. This bill is another example of Washington knows best approach that fails to consider our rural communities. It targets law-abiding gun owners while failing to keep firearms out of the hands of criminals. My amendment is a common sense clarification that protects our Montana way of life and preserves our farmers and ranchers' Second Amendment rights. I thank you, Mr. Chairman, for letting me testify, again, for this opportunity to speak, and I ask that you make this amendment in order.
Thank you very much. Mr. Armstrong?
Yeah, Mr. Chairman.
Just make sure your mic's on there. Okay.
It's on.
Okay, good.
My amendment is essentially the same as Mr. Gianforte's. I actually haven't seen his, but it's the same thing. I don't understand how we would have hunting, fishing, and trapping excluded under an exemption and not farming and ranching, particularly where we are at. We live in these rural areas. You're often hundreds of miles away from a FFL. And the types of activities that occur in these rural communities are not the problems H.R. 8 is trying to solve. I'm new here, so we've had these debates. We just listened to it here. We had it for 12 hours in the committee. I will be 100% honest. I won't support this bill in any form.
Okay.
However, I do think that it's incredibly important to deal with the realities that happen. And I think there's some things that should be pointed out for a temporary. One, the transfer for farming and ranching would be the temporary transfer, the same as hunting and fishing. Two, you can still continue to prosecute it if it's not legitimately being used for those things. And then with that, because I know it's getting late and we're going brief into that, I also would just point out wherever it is and however you can do it, outside of how you think this bill should go, somebody should really, really look at the exemptions in D and F, because the way they are written, this becomes a criminal penalty of which you can get prosecuted under. And to different degrees, F essentially federalizes game and fish law across the entire country. More importantly, it holds culpability for potential future conduct. And D, while the exemption in D is intended, I think, primarily for domestic violence victims or those types of issues, the way it is written, it is so narrowly tailored that I can't imagine how it actually be used in the real world. And to give you an example of that, I was back at home in district and I went to speak at my former law school, and knowing full well that the room would be pretty evenly split between people who probably like me and people who don't like me, I figured I'd give them a little legal test instead of a political test. So I read the exemption to D, and we spent a half hour discussing all of the different ways in which civil liability or criminal liability could or could not occur. That's not good code writing, and it should be cleaned up. So with that,
Thank you very much, Mr. Klein.
Mr. Chairman, I'm sure all of Mr. Armstrong's constituents love him, and a 50-50 split is never a good estimate. But
in fairness, they're law students and not all my constituents.
that's true. Mr. Chairman, thank you for the opportunity. Before we move on H.R. 8 to expand what is current law regarding background checks, we must ensure that the existing laws are being enforced. My amendment would simply require existing law to be enforced by asking the Attorney General to report to ICE the individual illegal aliens who have been denied a firearm transfer by a NICS check, which is already prohibited under the existing law. FBI reported last month that the background check system had nearly 8 million people listed as illegal unlawful alien, and additionally, illegal aliens ranks the '1 prohibited category in the FBI's NICS indices. Roughly 3,300 illegal aliens were denied a firearm after failing a NICS check in 2017. This means 3,300 criminals were effectively allowed to stay in the United States when ICE should have been alerted about their criminal acts. H.R. 8 does not do anything to prevent crime, and I encourage my colleagues to start focusing on the real threats to our nation and moving forward with legislation that protects the American people by stopping the violent gang members and drugs that are flooding across our southern border. H.R. 8 will only limit the constitutional rights of law-abiding citizens. Instead, Congress should be focused on pursuing and punishing the criminals who are a danger to our society, and my amendment would go a long way toward accomplishing that. Thank you, and I ask that my amendment be made in order.
Well, thank you very much. Mr. Armstrong, you have another?
Mr. Chair, I just wanted to point out that Congressman Hurd from Texas also asked to join the farming and ranching exemption. Okay. So we're dealing with Montana, North Dakota, and Texas.
The record will reflect that. Thank you very much for your testimony. I appreciate you waiting. Let me ask, anybody on our side have any questions or comments? Mr. Cole, anyone on this side? Mr. Woodall does.
I just wanted to ask Mr. Armstrong if he offered this amendment in committee, if it was considered in the committee.
I offered a broader amendment in committee, which was not accepted. This one's a more narrowly tailored one, just excluding or just adding farming and ranching to the exemptions.
Thank you.
Okay. Mr. Burgess.
Thank you, Mr. Chairman. I think these are all wonderful amendments, and it really indicative of the process that should be followed. And I think all of the amendments should be made in order and debated fully on the floor. I yield back.
Any other questions? No question. We're all set. Thank you very much for being here. Anybody else want to testify? Ms. Lesko. Hey, glad you made it in.
Thank you, Mr. Chair. Yeah, I just came right from the airplane, right to here.
We held the hearing open just for you.
All right. Oh, you're so sweet. Thank you. Are we at a point where I'm going to talk about my amendments?
Yes.
Awesome. Thank you very much. Thank you, Mr. Chair and members. I ask that you please consider the Lesko Amendment number 1. And basically what it does is give an exemption for victims of domestic violence and sexual assault who have an order of protection issued by the court. And the reason that I think this is important is because I think it's fair for and just for these victims to be able to defend themselves against their perpetrator. And often, because I'm a survivor of domestic violence, so I kind of know how this works, at least in my case, it's very difficult for a victim of domestic violence to get away from their perpetrator and go off and get these things, let alone pay for a gun or pay for if there's a fee for a background check. And so my understanding is H.R. 8 would prevent someone from just borrowing a gun from someone that they know or transferring a gun. And I think it is very important that that person is able to defend themselves, and I ask for your support.
Okay. You have another amendment too?
I do.
Okay.
Thank you. Members and Mr. Chair, I also ask that you please vote for Lesko Amendment number 2, entitled Global Entry Program. This amendment would allow gun owners to legally transfer their firearms to individuals who have been admitted and are participants in the Global Entry Program. And for those of you that are in the Global Entry Program, you know that it is done by the U.S. Customs and Border Protection, and you have to get a background check. So if you already have this, why have to go? Why should a law-abiding citizen have to go through another background check? All right.
You've heard the amendment. Any questions on, I said, Mr. Burgess, you have questions?
I do have.
Oh, you have a third amendment?
I have several amendments.
Oh, I'm sorry. Keep it going.
Thank you.
Oh,
Yeah,
I'm sorry.
thank you. And I'll be fast.
No, that's okay.
All right.
Take as long as you want.
And I ask for your approval of LESCO number 3 amendment. Deals with allowing a waiver for someone to temporarily transfer their gun when it's on their private property. So we're talking about someone on their private property, let's say it's a farm or a ranch, and if somebody else is on their property, I believe they should be able to temporarily transfer their gun on their property because they're law-abiding citizens, assuming that the people know each other. And to me, it's a violation of their rights, actually, Second Amendment rights. If you're on your own private property and you can't even temporarily transfer a gun, because under my what I've read on H.R. 8, this would make you a criminal if you did that. I also have LESCO number 4 amendment. This has to do with it would allow gun owners to legally transfer their firearms to individuals who have a federal government issued security clearance. So right here, my staff member, Matt, who's sitting right here, just recently applied to get a security clearance. This is all of the paperwork they have to do, along with the extensive background check. He had to get interviews. I think you had to go back for another interview. And so certainly if somebody has a security clearance and has gotten background checks, they should be able to be waived from having another background check in order to get a gun. And the LESCO number 5 amendment says that, I ask for your approval. This amendment allows for the transfer of a handgun to an individual who has a valid state-issued permit to purchase or license to own a firearm. So several states already require a permit. You have to go and get a background check in these states. So to me, it's very duplicative. If you're already in that state, and that you already have a permit to own a gun, why should you have to go through another background check to either buy a gun or get transferred for a gun? Makes total sense to me. And one more, LESCO number 6 amendment would allow gun owners to legally transfer their firearms to individuals who have been admitted and are participants in TSA's pre-check program. For those of you that are in the TSA pre-check program, you know you also have to do a background check for that. So to me, again, H.R. 8 would make this duplicative for people that already have a background check, law-abiding citizens that have been approved. Again, in my analysis, H.R. 8, although I'm sure very well-intentioned, would not have prevented any of the mass shootings that have taken place recently and would only impede law-abiding citizens. And these are some clear examples of how I believe they impede law-abiding citizens. And I ask for your approval on my amendment.
Thank you. You've heard the gentlelady's amendments. Any comments or questions? Mr. Burgess, you have a... Oh, okay. All right. No questions. Mr. Burgess has an amendment.
Thank you, Mr. Chairman. I've already heard a lot of the discussion around my amendment number 6 to H.R. 1112. Requires Department of Justice Inspector General to submit a report to Congress on the number of NICS denials referred for investigation, the number of prosecutions resulting from denial investigations, and the number of firearms recovered by ATF following delayed denials. I go back.
You heard the gentleman's amendment. Anybody have any questions or comments on it? I think that then anybody else have any amendments?
Taking amendments now.
Yeah, you have an amendment to offer? Yes. No, we're still in the hearing. Yeah, okay. Oh, yeah, okay. So hearing no one else here to testify, any amendments, this closes the hearing portion of the committee. And now, at this time, I would entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Thank you, Mr. Chairman. I move the committee report a structured rule for consideration of H.R. 8, the Bipartisan Background Checks Act of 2019. The rule provides 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for purpose of an amendment in the nature of a substitute consisting of the text of Rules Committee print 116-5 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those amendments printed in Part A of the Rules Committee report accompanying the resolution. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against amendments printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 1112, the Enhanced Background Checks Act of 2019, under a structured rule. The rule provides 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee print 116-6 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent, and an opponent shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule waives all points of order against amendments printed in Part B of the report. Finally, the rule provides one motion to recommit with or without instructions.
So as we just heard from the gentleman from Maryland, this rule provides for consideration of H.R. 8 and H.R. 1112. The rule makes an order 4 amendments for H.R. 8 and 5 amendments for H.R. 1112. These are common sense measures that close loopholes and fix our background check system. I hope it wins with an overwhelming bipartisan vote tomorrow. You've heard the motion from the gentleman from Maryland. Is there any amendment or discussion? Mr. Cole.
Thank you very much, Mr. Chairman. I'll be offering 3 amendments. The first one is to H.R. 8. I've got an amendment to the rule to make an order amendment number 29 offered by Mr. Stubbe of Florida. This amendment requires the National Instant Criminal Background Check System to notify the Immigration and Customs Enforcement Agency of the Department of Homeland Security whenever the information available to the system indicates that a person illegally or unlawfully in the United States may be attempting to receive a firearm. The amendment's almost identical to the one offered by our colleague, Mr. Sisleen. It's a good, responsible governing to ensure the enforcement of laws that are already on the books and the sharing of information regarding illegal attempts to receive a firearm are a critical part of law enforcement.
Heard the gentleman's amendment. Any discussion or comments? Hearing none, the vote will be on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it.
Mr. Chairman, we have a recorded vote.
Clerk will call the roll.
Mr. Hastings?
No.
Mr. Hastings votes no. Ms. Torres? Ms. Torres votes no. Mr. Perlmutter? Mr. Perlmutter votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Murley? Ms. Shalila? Ms. Shalila votes no. Mr. Desonier? Mr. Desonier votes no. Mr. Cole?
Aye.
Mr. Cole votes aye. Mr. Whittle?
Aye.
Mr. Whittle votes aye. Mr. Burgess?
Aye.
Mr. Burgess votes aye. Mrs. Lesko? Aye. Mrs. Lesko votes aye. Mr. Chairman?
No.
Mr. Chairman votes no.
Clerk will report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment to the rule to make an order amendment number 12 offered by Mr. Collins of Georgia. The amendment allows an FFL who was contacted by NICS to rely on the information provided by NICS respecting a transfer for 60 days after the FFL's initial date of contact. Drafting the legislation fails to recognize the unworkability of the time frame laid out compared to the 30-day time period in which NICS process runs. By extending the current 30 days to 60 days, bill may actually function as designed.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote will be on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Roll call, Mr. Chairman.
Clerk will call the roll.
Mr. Hastings. No. Mr. Hastings votes no. Mrs. Torres. Mrs. Torres votes no. Mr. Perlmutter. No. Mr. Perlmutter votes no. Mr. Raskin. No. Mr. Raskin votes no. Ms. Scanlon. No. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. No. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole.
Aye.
Mr. Cole votes aye. Mr. Woodall.
Aye.
Mr. Woodall votes aye. Mr. Burgess.
Aye.
Mr. Burgess votes aye. Mrs. Lesko. Aye. Mrs. Lesko votes aye. Mr. Chairman.
No.
Mr. Chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to.
Mr. Chairman, one last amendment for me. I have an amendment in the rule to make an order and provide the necessary waivers for amendment number 14 offered by Mr. Rowe of Tennessee. The amendment clarifies that a person shall not be considered to be adjudicated under Title 18 as a result of any determination by the Secretary of Veterans Affairs under any laws administered by the Secretary of Veterans Affairs under Title 38. It's a clarifying amendment, Mr. Chairman, that ensures that the unintended consequences of H.R. 1112 do not spill over into the U.S. Code provisions related to the VA. It's purely technical in nature and should be supported.
You heard the amendment from the gentleman from Oklahoma. Any discussion? Hearing none, the vote will be on the gentleman's amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings. No. Mr. Hastings votes no. Mrs. Torres. Ms. Torres votes no. Mr. Perlmutter. Mr. Perlmutter votes no. Mr. Raskin. No. Mr. Raskin votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. No. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole.
Aye.
Mr. Cole votes aye. Mr. Woodall.
Aye.
Mr. Woodall votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Lesko. Aye. Mrs. Lesko votes aye. Mr. Chairman.
No.
Mr. Chairman votes
Clerk will report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Any other amendments?
Mr. Chairman.
Woodall.
I have 2 amendments. Thinking about the success in Massachusetts, Mr. Palmer has an amendment number 16. I move that we make that in order. It recognizes that state laws and regulations are already active in this area and that nothing in this bill is intended to override those states that have already been successful.
Well, not everybody's Massachusetts, but
well, we all aspire to be in that way. I want to recognize that. So I move we make amendment number 16 in order to respect those states that have been successful in this area.
I think this amendment would probably gut the bill, but in any event, you heard the gentleman's amendment. Any discussion? Hearing none, the vote will be on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Mr. Chairman, I have a roll call vote.
Clerk will call the roll.
Mr. Hastings.
No.
Mr. Hastings votes no. Mrs. Torres. Ms. Torres votes no. Mr. Perlmutter. Mr. Perlmutter votes no. Mr. Raskin. Mr. Raskin votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole.
Aye.
Mr. Cole votes aye. Mr. Woodall.
Aye.
Mr. Woodall votes aye. Mr. Burgess.
Aye.
Mr. Burgess votes aye. Mrs. Lesko. Aye. Mrs. Lesko votes aye. Mr. Chairman.
No.
Mr. Chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
The amendment is not agreed to. And before I go back to Mr. Woodall, I want to ask unanimous consent to insert in the record the statement from Congresswoman Sheila Jackson Lee of Texas on the bills we're discussing. Mr. Woodall.
Thank you, Mr. Chairman. For folks who wanted to be with me last time, everyone heard Mr. Gianforte's very persuasive case about folks in rural Montana and their need to have a very small exception made for ranch activities. I cannot say it any better than he said it. I believe this is probably just an oversight. I would like to have move this amendment be included.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it. Clerk will call the roll.
Mr. Hastings. No. Mr. Hastings votes no. Mrs. Torres. No. Ms. Torres votes no. Mr. Perlmutter. No. Mr. Perlmutter votes no. Mr. Raskin. No. Mr. Raskin votes no. Ms. Scanlon. No. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. No. Ms. Shalala votes no. Mr. Desaulnier. No. Mr. Desaulnier votes no. Mr. Cole.
Aye.
Mr. Cole votes aye. Mr. Woodall.
Aye.
Mr. Woodall votes aye. Mr. Burgess.
Aye.
Mr. Burgess votes aye. Mrs. Lesko. Aye. Mrs. Lesko votes aye. Mr. Chairman.
No.
Mr. Chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
The amendment is not agreed to. Any other amendments? Mr. Burgess.
Thank you, Mr. Chairman. I also have 2 amendments. I have an amendment to the rule to make an order and provide the necessary waivers for the amendment I discussed to H.R. 1112, amendment number 6. This requires the Department of Justice Inspector General to submit a report to Congress on the number of NICS denials referred for investigation, the number of prosecutions resulting from denial investigations, and the number of firearms recovered by ATF following NICS denials.
Heard the gentleman's amendment. Any discussion? Hearing none. The vote is on the Burgess amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Roll call.
The clerk will call the roll.
Mr. Hastings. No. Mr. Hastings votes no. Mrs. Torres. Mrs. Torres votes no. Mr. Perlmutter. Mr. Perlmutter votes no. Mr. Raskin. Mr. Raskin votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole. Mr. Cole votes aye. Mr. Whittle. Mr. Whittle votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Lesko. Mrs. Lesko votes aye. Mr. Chairman.
No.
The chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
Not agreed to any further amendments. Mr. Burgess.
Mr. Chairman, I have an amendment to the rule and make it in order and provide the necessary waivers for amendment number 3 offered by Mr. Brown of Maryland. This amendment requires that individuals must be 21 years of age to purchase a semi-automatic centerfire rifle that has or can accept a magazine of more than 5 rounds and provides an exemption for active duty military members and full-time law enforcement officers.
You heard the amendment from the gentleman from Texas. Any discussion? Hearing none, the vote is on the Burgess amendment. All those in favor say aye. Aye. Opposed, no. No. And the chair, the noes have it. Roll call. Clerk will report. Clerk will call the roll.
Mr. Hastings.
No.
Mr. Hastings votes no. Mrs. Torres. Mrs. Torres votes no. Mr. Perlmutter. Mr. Perlmutter votes no. Mr. Raskin. No. Mr. Raskin votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole. Aye. Mr. Cole votes aye. Mr. Whittle. Aye. Mr. Whittle votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Lesko. Mrs. Lesko votes aye. Mr. Chairman.
No.
Mr. Chairman votes
Clerk
no.
report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Any further amendments? Ms. Bridges? Ms. Lesko? Yeah.
Mr. Chair, I have an amendment to the rule to make an order. Amendment number 28 offered by Mr. Scalise of Louisiana. This amendment allows the transfer of a firearm to a victim of domestic violence or sexual assault. An individual protected under an order of protection issued by a court of law, a person with a valid concealed carry permit, a member of the armed forces who is on active duty, or an active duty or retired law enforcement officer. Mr. Chairman and members, to me, this is a common sense amendment. Again, as I've said before, I think that victims of domestic violence and sexual assault should be permitted to protect themselves. They often do not have the means to purchase a gun and would like to borrow perhaps one to defend themselves, and H.R. 8 would make them a criminal if they do so. In addition, it is common sense for a person with a concealed carry permit that already has gone through a background check to be able to waive the additional background check. And of course, the member of the armed forces on active duty or an active duty or retired law enforcement officer, I'm sure that we trust them to carry their own guns. And so to me, it makes no sense that they would have to go through another background check.
You heard the general lady's amendment. Any discussion? I just want to ask unanimous consent to insert in the record a statement for the National Task Force to End Sexual and Domestic Violence opposed to this and some other amendments that have been raised here today. So no other discussion. The vote will be on the Lesko amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Aye. Roll call vote, please.
Clerk will, roll call vote has been requested. Clerk will report, call the roll.
Mr. Hastings. No. Mr. Hastings votes no. Mrs. Torres. Mrs. Torres votes no. Mr. Perlmutter. Mr. Perlmutter votes no. Mr. Raskin. Mr. Raskin votes no. Ms. Scanlon. Ms. Scanlon votes no. Mr. Morelli. Ms. Shalala. Ms. Shalala votes no. Mr. Desaulnier. Mr. Desaulnier votes no. Mr. Cole. Mr. Cole votes aye. Mr. Whittle. Mr. Whittle votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Lesko.
Aye.
Mrs. Lesko votes aye. Mr. Chairman.
No.
Chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
Members not agreed to. Any further amendments?
Mr. Chair, I do have several more amendments.
Okay.
Mr. Chair, I have an amendment to the rule to make an order. Amendment number 11 offered by myself, Mrs. Lesko from Arizona. This amendment allows for the transfer of a firearm to a victim of domestic violence or sexual assault who has an order of protection issued by a court. I think I've already explained this, and with no disrespect to the National Task Force, I have been in this position, And so I think that I would know what, I have the experience, and so I would ask members to vote for this.
Heard the Lesko amendment. Any discussion? Hearing none, the vote is on the Lesko amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Ask for a roll call vote.
Roll call vote is requested. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings votes no. Mrs. Torres? Mrs. Torres votes no. Mr. Perlmutter? Mr. Perlmutter votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Morelli? Ms. Shalala? Ms. Shalala votes no. Mr. DeSaulnier? Mr. DeSaulnier votes no. Mr. Cole? Mr. Cole votes aye. Mr. Woodall? Mr. Woodall votes aye. Mr. Burgess? Mr. Burgess votes aye. Mrs. Lesko?
Aye.
Mrs. Lesko votes aye. Mr. Chairman?
No.
Mr. Chairman votes no.
Clerk report the total.
4 yeas, 8 nays.
The amendment is not agreed to. Any further amendments? May I inquire how many more amendments you have? Because we might want to.
1, 2, 3, 4.
All right. I think we're going to recess for votes.
All of them at
You want to
once?
do all in one?
Can we do that?
Or if you do them all at once, we'll do it. Okay.
All right.
All right.
All right. Thank you, Mr. Chair. I have an amendment to the rule to make an order amendment number 12 offered by myself, Mrs. Lesko. Amendment number 13 offered by myself, Mrs. Lesko. Amendment number 14 offered by myself, Mrs. Lesko. And amendment number 20 offered by myself, Mrs. Lesko. We had discussed these previously, and I think that they're all good. They're for law-abiding citizens. I think H.R. 8 gives undue burden on law-abiding citizens that already have background checks. With that, I request members to vote aye.
You heard the gentlelady's amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it. Want a roll call? Clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres votes no. Mr. Perlmutter? Mr. Perlmutter votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Morelli? Ms. Shalala? Ms. Shalala votes no. Mr. DeSaulnier? Mr. DeSaulnier votes no. Mr. Cole? Mr. Cole votes aye. Mr. Woodall? Mr. Woodall votes aye. Mr. Burgess? Mr. Burgess votes aye. Mrs. Lesko? Mrs. Lesko votes aye. Mr. Chairman?
No.
Mr. Chairman votes no.
Clerk will call, report the total.
4 yeas, 7 nays.
The amendment is not agreed to. Are there any other amendments or discussion? Hearing none, the question is now on the motion offered by the gentleman from Maryland. All those in favor will say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it, and the motion is agreed to. Clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres votes aye. Mr. Perlmutter? Mr. Perlmutter votes aye. Mr. Raskin? Mr. Raskin votes aye. Mrs. Scanlon? Ms. Scanlon votes aye. Mr. Morelli? Ms. Shalala? Ms. Shalala votes aye. Mr. DeSaulnier? Mr. DeSaulnier votes aye. Mr. Cole? Mr. Cole votes no. Mr. Woodall? Mr. Woodall votes no. Mr. Burgess? Mr. Burgess votes no. Mrs. Lesko? Mrs. Lesko votes no. Mr. Chairman?
Aye.
Mr. Chairman votes aye.
And how was Mr. Hastings recorded?
He is not recorded. Mr. Hastings votes aye.
All right, the clerk will report the total.
8 yeas, 4 nays.
The ayes have it, the motion is agreed to. Accordingly, Mr. Raskin will manage this for the majority. All right, at this time, the chair will entertain a motion from the distinguished gentleman from California, Mrs. Torres.
Mr. Chairman, I move the committee grant H.J. Res. 46 relating to the national emergency declared by the President on February 15, 2019, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Transportation and Infrastructure. The rule waives all points of order against consideration of the point resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 motion to recommit. Finally, the rule provides that provisions section 202 of the National Emergencies Act shall not apply during the remainder of the 116th Congress to a joint resolution terminating the national emergency declared by the President on February 15, 2019.
You've heard the motion from the gentleman from California. Are there any amendments or discussion? Here. All right, Mr. Hastings.
Mr. Chairman, I don't have a motion, but I ask unanimous consent to approve the statement that I would have made on the record.
Without objection, Mr. Burgess.
Did I miss the hearing on this part?
Yes, no, you did not. No, this is an emergency the president declared, and we're responding to the emergency. So, Ms. Lesko.
Thank you, Mr. Chair and members. I will be voting no on House Joint Resolution 46. I live in a border state on Arizona. There is an emergency on the border. I've been to the border. There's an emergency on the border. There's a crisis on the border. There's hundreds and thousands of people flooding into our nation. We don't know who they are. My constituents demand that the border be secured.
I appreciate that. This is, the president said that he didn't have to do it. So he, by his own admission, said it wasn't an emergency. And this is about, quite frankly, protecting our constitutional prerogatives and powers as the legislative branch. And so at this point, the vote will be on the motion of the gentlewoman from California. All those in favor say aye. Aye. All those opposed say no.
No.
In the opinion of the chair, the ayes have it.
Roll call.
And the clerk will call the roll.
Mr. Hastings. Aye. Mr. Hastings votes aye. Mrs. Torres. Aye. Mrs. Torres votes aye. Mr. Perlmutter. Aye. Mr. Perlmutter votes aye. Mr. Raskin. Aye. Mr. Raskin votes aye. Ms. Scanlon. Aye. Ms. Scanlon votes aye. Mr. Morelli. Ms. Shalala. Aye. Ms. Shalala votes aye. Mr. Gisania. Aye. Mr. Gisania votes aye. Mr. Cole.
No.
Mr. Cole votes no. Mr. Woodall.
No.
Mr. Woodall votes no. Mr. Burgess.
No.
Mr. Burgess votes no. Mrs. Lesko. Mrs. Lesko votes no. Mr. Chairman.
Aye.
Mr. Chairman votes aye.
Clerk will report the total.
8 yeas, 4 nays.
The motion is agreed to and it will be carried by Ms. Torres for the majority. Without objection, the committee stands adjourned.
Yeah, sorry. Yes.